Welcome to the Explainer. Okay, let's jump right in, because today we are exploring a truly fascinating intersection of law, freedom of expression, and artificial intelligence. We're going to be looking at a real-world legal case from China and examining exactly what happens when you take a defendant's arguments and feed them into 6 of the world's most advanced AI models. It's a completely novel way to analyze legal and political friction, and honestly, the results are pretty mind-blowing. So, our roadmap for today covers a few key areas. First, we've got the Chen Jingyuan case itself. Then, AI evaluates the defense. After that, we'll hit policy versus local enforcement, criminalizing academic and political debate, network sovereignty and diplomacy, and finally, we'll wrap up with the systemic risks and implications. All right, Section 1, the Chen Jingyuan case. Let's get the facts down first. So, Dr. Chen Jingyuan. He's an independent scholar, holds a PhD in physics. Now, between 2019 and 2022, he retweeted various posts on Twitter. And keep in mind, Twitter is blocked in China, but it is accessible if you use a VPN. While in September 2022, police in Kunming suddenly raided his home and arrested him. Fast forward to January 2023, he's indicted, and by April, he was sentenced to 1 year and 8 months in prison. And this was all over social media retweets.
Now, the contrast between the two arguments in court was incredibly stark. The prosecution leaned on a charge known as picking quarrels and provoking trouble. They argued that Dr. Chen knowingly spread false information, which they claimed caused severe public disorder. The defense, on the other hand, pointed out a few crucial details. First, he had fewer than 100 followers. Second, he was literally just retweeting art, academic opinions, and public statements from foreign officials. And third, there was absolutely zero tangible proof of any actual public disorder.
That brings us to Section 2. AI evaluates the defense. This is where things get really interesting.
While he was in prison, Dr. Chen actually wrote a comprehensive defense document. He called it his blood letter. In it, he argued his case from a very high-level policy perspective. Well, researchers took this defense alongside the official legal judgments and fed the whole package into 6 major large language models. We're talking ChatGPT, Copilot, DeepSeek, Gemini, Grok, and Qwen. They basically use these systems to act as an impartial, highly analytical panel to evaluate the profound legal and political implications of his conviction.
And the central premise they were testing was this macro versus micro arc. See, Dr. Chen didn't just stand up and say, hey, I'm innocent on the facts. He argued something much bigger. He argued that local, micro-level law enforcement in Kunming was directly contradicting China's macro-level national strategies. So the AI models were tasked with figuring out, was this local enforcement actually undermining the country's overarching state policies? Let's dig into that in Section 3, Policy versus Local Enforcement. To really understand the defense's argument, we have to define the community of common destiny. This is a major, overarching national diplomatic strategy in China. It heavily emphasizes cultural exchange, diversity, and mutual learning among different civilizations. It's a big deal. And it's the exact benchmark Dr. Chen used to measure those local judicial actions against. When the models looked at this, there was a fascinating consensus. Models like ChatGPT and Copilot universally flagged a massive contradiction. They pointed out that punishing a citizen for exploring foreign perspectives, like retweeting foreign officials, directly conflicts with that open, tolerant framework of the community of common destiny. Basically, the AI highlighted that the local enforcement in Kunming was essentially working completely against the state's very own diplomatic narrative. Which leads right into Section 4, Criminalizing Academic and Political Debate. As we touched on earlier, Dr. Chen was convicted of picking quarrels and provoking trouble. Now, in Chinese law, this is often referred to as a pocket crime, meaning it's a very broad, catch-all charge that you can stuff a lot of different things into. In this specific case, local police used it to target the retweeting of foreign speeches, including speeches by Donald Trump, as well as academic criticisms and even political art. The critical takeaway here is a distinction that DeepSeek and Grok immediately picked up on. They observed that the court completely failed to distinguish between objective facts and value judgments. Objective facts can be proven true or false, right? But academic debate, art, and political opinions inherently lack a strict true or false standard. You can't put a truth value on a painting or a political hot take. The AI noted that by categorizing political debate as fake news or rumors, the court was dangerously erasing the space for any kind of rational discussion. And then Gemini made a truly wild observation. The court actually cited Dr. Chen's high education, his PhD in physics, against him. The judgment argued that because he's highly educated, he, quote, should have known better. They framed his intellect as actual proof of malicious intent.
The AI models identified this legal logic as objective imputation, which is basically a presumption of guilt based entirely on your status. They noted this completely contradicts the national policy of respecting talent and obviously creates a severe chilling effect for intellectuals across the board.
Moving on to Section 5, Network Sovereignty and Diplomacy.
This entire situation poses a really massive question. Can domestic courts police foreign speech on foreign platforms? This hooks us right into the incredibly complex web of international law and extraterritorial jurisdiction. Remember, Dr. Chen was retweeting on Twitter, which is a U.S. platform, and some of the content he shared included official statements from the U.S. Embassy in China.
So this brings up the principle of non-interference. It's a core tenet of international law, basically stating that nations shouldn't intervene in the internal affairs of other states. Dr. Chen argued this standard was totally violated when local police used domestic criminal law to target his retweets of official foreign government statements.
The AI models, particularly Quen and Grok, analyze this angle intensely, and their consensus? Labeling foreign official statements as domestic rumors risks serious diplomatic friction, and it totally oversteps jurisdiction. The AI warned that using local criminal law to judge the truthfulness of another government's statements could severely impact international relations. Not to mention, it contradicts the nation's own diplomatic stance on non-interference.
Finally, let's wrap up with Section 6, Systemic Risks and Implications.
When we look at the breakdown across these models, there is a completely objective consensus among these distinct AI systems. Whether it's ChatGPT, DeepSeek, or Gemini, they all independently concluded the exact same systemic flaws. On the policy clash, they see restricted exchange and damaged soft power. On chilling debate, they see the suppression of viewpoints and the destruction of rational discussion. And on diplomatic risk, they all flag the challenge to sovereignty and international law. They are all reading the same warning signs.
So why does all this matter? Well, this single micro-level case ripples outward in a big way. The AI models basically summarized 4 main systemic risks here: a severe chilling effect on academic and public discourse, the dangerous, unchecked expansion of pocket crimes like picking quarrels, tangible damage to the nation's international image, and fundamentally the erosion of the rule of law and basic evidentiary standards.
There was one profound concluding thought from the Quen AI model that really stood out during this analysis. It stated, the grander the policy advocacy, the more restrained legal application must be. That just perfectly captures the tension here between high-level national strategy and the messy realities of local enforcement.
Which leaves us with a final, rather provocative thought to chew on. When local enforcement directly contradicts national strategy and international law, who ultimately pays the price? It's a question that goes far beyond one scholar in Kunming. It speaks to the very heart of how we evaluate legal systems and freedom of expression in the digital age. Thanks for joining me on this explainer, and I hope this provided a clear, structured look into a deeply complex issue. Catch you next time.